Okay, good morning, everyone.
Good morning.
Good morning, Your Honor.
Okay.
Good morning, Your Honor.
Good morning.
Your Honor.
Morning.
Morning, Your
Okay.
Honor.
We are going to get started, and I'd just like for each attorney, well, one housekeeping matter. We received the call from Attorney Moorhead, who indicated he had an emergency, and he requested that his case be placed last. So Attorney Clement, we will move that down to number 4 and move up number 4 to number 3. So with that, I will formally open this session of the Supreme Court oral arguments for October 13th, 2020. And I will welcome all of the attorneys who are participating in the 4 cases that we have for oral argument today. I initially said we would call a roll of all of the attorneys, but I can see that we have just about everyone except Attorney Moorhead, and so we will just call the cases. And again, we will allow you 3 minutes uninterrupted to make your case before we start asking questions. You will see there's a time clock up in the left-hand corner. Keep your eye on that, and when it turns red, you should simply stop, finish up your argument, and then we'll move on to the others. As you come up, indicate if you wish to reserve any time for rebuttal, and the clerk in the courtroom will note that and adjust the time accordingly. So we will call the first case, Emanuel Greer versus the people of the Virgin Islands, number 25 of 2018. Attorney Gobelinsky, you're free to, well, both of you indicate your appearance.
Good morning to the court. My name is Alex Golubitsky, Golubitsky, appearing on behalf of the appellant Emanuel Greer.
Attorney Gregory.
Good morning. Assistant Attorney General Aisha Gregory, appearing on behalf of the people of the Virgin Islands, the appellee.
Attorney Gobelinsky, you're free to commence your argument.
Thank you, Your Honor, and may it please the court. We're here today on the appeal. Oh, I'm sorry. I'd like to reserve 3 minutes for rebuttal.
Very well. Thank
you, Your Honor. We're here today on Emanuel Greer's appeal of the guilty verdict. We're here today on the appeal of Emanuel Greer's denial of the motion for judgment of acquittal he filed after the jury had returned a guilty verdict on 1 count of mayhem. The issue raised by Mr. Greer on appeal is whether there was sufficient evidence in front of the jury to allow the jury to find that Mr. Greer was guilty of the crime of mayhem. Specifically, the issue that's raised by Mr. Greer is the applicability of 14 VIC section 1344 in the court's analysis of the trial court's analysis of Mr. Greer's motion for judgment of acquittal. This section 1344 of the Virgin Islands Code, Title 14 of the Virgin Islands Code, provides that in the event of a trial for mayhem, when it appears that the person injured at the time of trial is no longer disfigured in his personal appearance, his or her personal appearance, no conviction for mayhem can be had, although a conviction may be had for assault in any degree. In the trial in this particular case, the victim presented no evidence whatsoever that he continued to be disfigured by his injury at the time of the trial, although there was evidence of disfigurement at the time of the injury. Section 1344 references the time of the trial, not the time of the injury. And because there was no evidence at the time of the trial of a serious disfigurement, or it appeared at least that the victim had recovered, no conviction may be had as a matter of law for the crime of mayhem. In addition, in testimony in the trial, the victim's treating physician testified that the victim was not seriously disfigured. In fact, she described the injuries suffered by the victim as a mild disfigurement, which would fall outside of what Section 1341 sub A1 of Title 14 requires for the crime of mayhem. In the trial court's opinion on the defendant's motion for judgment of acquittal, the trial court, and this is also pointed out by the people in their response to the appellant's appeal, says that there's no definition of serious disfigurement in the Virgin Islands Code, and what the trial court relied on is a definition of serious disfigurement from the New York State Penal Code. And the appellant argues that that is not sufficient for first of all, because the New York statute relates to, in general, assault, not specifically to mayhem, and because they're actually, even though Section 1344 does not provide a specific definition of serious disfigurement, it is a Virgin Islands law which requires a showing, which provides an evidentiary basis on which a conviction of mayhem can be held. And in the trial,
let me ask you, could the jury view the victim's ear as he testified in court or as he sit in the courtroom and make a determination whether or not the lack of the piece of the ear that was missing, that was enough of a disfigurement? Could they make that determination without him being displayed before the jury?
Well, it's not clear that they could, Your Honor, because there's no evidence in the record that suggests that anybody in the jury was able to see the victim's ear from where he was situated in the witness stand. I'm not sure. There's nothing in the record which indicates, for example, which side of the victim the jury would have been on with respect to his, which ear was injured. And I can't recall how Judge Mackay's courtroom is laid out, that whether or not that would have been possible. And in any event, there's nothing in the record to indicate.
Attorney, I have a burning question.
Yes, Your Honor.
And am I correct? Am I correct that there were some photographs taken of the victim's ear and his head? Am I correct?
Yes, Your Honor, that is correct.
And those were admitted in evidence?
Yes, that's correct.
Good. Now, am I correct that after the ear was bitten off and the police officer put it on ice and rushed it up to the medical facility where the victim was, the same doctor that said that it might have been a mild disfigurement, she said the ear and the part that was severed was already dead, so it couldn't be reattached. And therefore, he has to go through life with a part of his ear, which is very much pronounced when you look at him, no matter what kind of locks that he might have. But when you talk about serious disfigurement, isn't that the jurors were entitled to reject the nurses or the Dr. Bosco's definition that it was mild, and upon seeing the photographs and knowing that it could not be reattached, knowing it's a permanent injury and disfigurement, could they have not find it to be serious disfigurement under the statute?
Well, no, Your Honor, because again, Section 1344 requires a measure of proof beyond the injury at the time, how the injury looked at the time of the injury, because Section 1344 specifically references the trial itself. And so,
but wait a minute, there was nothing at the time of trial. Didn't he have the same appearance that he had unless he had plastic surgery, which is not in the record, to reattach that ear or do something with that ear. But am I correct that the same way that he appeared to the doctor with a severed ear that couldn't be reattached is the same appearance he had in the photographs and the same appearance he had when he showed up for trial?
Well, you could make that assumption, but the reason that 1344 exists.
In the record that he had plastic surgery or had subsequent medical attention to camouflage the severe the part of the ear that was severed?
Well, no, Your Honor. I mean, there's no evidence with respect to plastic.
The reason why there's nothing in the record is because it never happened. As a matter of fact, when he got there, he was kind of skittish about wanting to exhibit his ear to the jurors, but they already had the photographs. And if they see that ear, there's no question that the only thing that could put that ear back would have to be surgery.
Well, that's not in the record, Your Honor. I mean, there's nothing in the record that says that he had surgery, but there's also nothing in the record that says
that he had surgery. I'm saying that the injury is so severe, is so serious, that the only thing that can rectify the disfigurement would have to be surgery. Because remember, the ear that was retrieved at the scene of the crime and taken to the medical facility, whether it was the Keaton medical facility or what, they didn't even make an attempt to attach it because it already was dead. There was not reattachment, so therefore he had, and there's nothing in the record to suggest that he had any subsequent medical attention to rectify that disfigurement. And if the jurors believe, the jurors have a right to reject the doctor's term because the doctor and the jurors do not disagree on the disfigurement. It might be mild to her as a doctor, but to the lay people on that jury, and when they look at him and look at the photograph, well, they would find it to be a serious disfigurement.
Well, Your Honor, I think that the important thing here is that Section 1344 requires the analysis to not just happen at the time of the injury, right? I mean, we have to give meaning to the statutes that are enacted by the legislature, and the legislature, in fact, enacted a statute which says that you look at the injury at the time of trial to determine if it's a severe disfigurement or not. Not at the time of the injury. So let
me ask you this: was there any change anywhere in this record? Was there a change in the disfigurement from the time of the incident over in St. John to the time he was tried on St. Thomas years later?
Well, of course, Your Honor, because he received some medical treatment after the pictures were taken.
Medical treatment to what? To impinge upon the disfigurement?
Correct. I mean that's why they took him to the doctor.
Where in the record, because I must have missed that. I don't believe that. Did he have plastic surgery? Did he have common surgery? I know they give him antibiotics once he get there, and they tell him that that this part of the severed ear is not any good, so they didn't even take it.
Well, Your Honor, any injury is going to look different at the time of the injury than it would months later.
I am talking about is what was the difference? Was there any difference between the injury that he had at the time of trial and the injury he sustained at the date of the incident?
Attorney Golubitsky, can you hear me, sir?
I can hear you now, Justice Cabral.
Good, thank you. You stressed to us Section 1344. Does not that section indicate that the person has so far recovered from the injury that he is no longer disfigured? Are those words in the statute? I just read it partially.
Yes, Your Honor. That he's so far recovered from the injury that he is no longer disfigured by it in personal appearance. That's correct.
Well, I guess, I did not, the doctor, Dr. Barrett, whose testimony you used for the Rule 29 motion, or at least trial counsel used for the Rule 29 motion, even though she indicated that the injury may not have been a serious disfigurement. She indicated that he was going to be permanently disfigured. Did she not indicate that?
Well, yes, she indicated that there would be a permanent effect. Yes, that's correct. But people recover. I mean, this is the nature of the human body, right? Which is why Section 1344 points to the time of trial as the time when the jury infers whether there's a serious disfigurement. Not every alteration to the body is a serious disfigurement.
But what evidence is there on this record that the victim had recovered?
Well, the evidence is that the doctor testified that the disfigurement was mild. So if the disfigurement at the time of the injury was mild, and the jury could not infer from the appearance of the defendant at trial that the disfigurement was permanent, was that it continued to affect his personal appearance, then there wasn't sufficient evidence to sustain a conviction of mayhem.
In this case, was there ever any attempt by the government, the people, to display the injury to the jury so that they could make a determination based on his personal appearance at the time of trial that he had recovered so that he was no longer physically disfigured?
There's no evidence. There's nothing like that in the record, Your Honor.
Is this a defense, or is it an obligation on the government case in chief to prove that the injury is still permanent and is still disfiguring?
It's incumbent on the government to demonstrate it, because it goes to Section 1344 goes to the element of serious disfigurement in the crime of mayhem. So it's not akin to, for example, an affirmative defense, which must be raised in order to be relied upon by the defendant. It's a description of the element of the crime, and is therefore part of what the government needs to prove, not something the defendant needs to disprove.
So you didn't raise it until after the case was finished and you got to the jury instructions that you requested a jury instruction on that. Is that correct?
That's correct, Your Honor.
Attorney, did you see People's Exhibit number 2 that was admitted at trial, and People's Exhibit number 3? Did you have a close look at those 2 photographs of the defendant's injury?
Yes, Your Honor.
All right. And I mean, this is a permanent something, unless the only thing that can correct this is surgery and a rebuilding of the ear, that part of the ear that was severed. So it's a permanent disfigurement. Absolutely no question about it.
Okay, thank you.
And everywhere that he goes, people are going to notice that.
Yeah. Okay, thank you. We'll now hear from the people. Connie Gregory.
Good morning. May it please the court, Assistant Attorney General Aisha Gregory, appearing on behalf of the people of the Virgin Islands. This is a case that provides the court with the opportunity to define the term serious disfigurement under the Virgin Islands Mayhem Statute. Appellant has argued that the lower court erred by following New York law to define serious disfigurement. Your Honors, this argument is flawed. Given that the wording of the Virgin Islands Mayhem Statute is based on the New York Penal Law, Section 1400, this court may look to New York law for guidance. Specifically, in People v. McKinnon, the New York Court of Appeals provided an objective standard for serious disfigurement, which considers the location of the injury and the aspects of the victim's overall appearance. Ultimately, the court determined that serious disfigurement occurs when a reasonable observer would find her altered appearance distressing or objectionable. This court can and should rely on this objective standard for interpreting Title 14, Section 1341A1. Second, appellant has argued that the people failed to provide sufficient evidence of serious disfigurement. and that the injury was mild. Your Honors, once again, this argument is flawed. While growling like a pit bull, the defendant pulled, tugged, and shook his head in order to rip off a portion of Mr. Akima Williams's ear with his teeth. At trial, Dr. Barreau, the treating physician, testified that the severed portion could not be reattached due to a loss of blood flow and that the severed portion was no longer viable. But more importantly, Dr. Barreau explained that Mr. Williams would be disfigured for life. And third, appellant has argued that Mr. Williams failed to demonstrate that he was seriously disfigured at the time of trial. Your Honors, this argument is flawed. At the time of trial, Mr. Williams himself testified to the permanency of his injury. He testified that he's deformed and can't be around people, which demonstrates that his altered appearance is distressing or objectionable to the public. He still has headaches because it feels like his ear is trying to come back. And at night when he's laying in bed, he can only sleep on one side. The appellant has not presented any arguments that warrant a reversal of the jury's decision to find him guilty of mayhem. As such, this court must uphold the conviction for mayhem and affirm the court's order denying the motion for judgment of acquittal. Thank you, Your Honors.
Attorney, I noticed that you only cited one case coming out of New York. You said that our statute that was modified from the earlier statute is premised upon the law in New York, but
Right.
You forget some good old-fashioned cases coming out of New York, like the 1992 case of People versus Brown and the 1990 case from the New York Appellate Division, People v. Stevens, that those two cases apparently dealt directly with ear and ear lobes. And the courts there didn't have any hesitancy or compunction about finding that that was substantial and serious disfigurement because it can be reattached. So, so if we follow our statute that is based upon from New York, it was imported from New York statute, People v. Brown and People v. Stevens directly address the issue of the ear and the ear lobe, or at least the ear part of it. If you, this is certainly with Mr. Williams' loss of a large portion of the ear was a more serious disfigurement than a depression in one's thigh. And then you talk about where, for example, it was deemed sufficient for serious injury when the victim suffered a gunshot wound that inflicted serious and substantial disfigurement. But later on down, we have at least another case, which you might have cited, was People v. Efonte. Did you talk about Efonte?
No, I didn't talk about Efonte.
Or that's a 1995 one. Is it? A conviction was also upheld where the defendant bit off the victim's earlobe, and that was found to be sufficient evidence of a serious and permanent disfigurement. He is permanently disfigured. And if a permanent disfigurement to the ear, that if that's not serious business, then there's no such thing as serious business. That's a serious injury.
You're right, Your Honor. This is a textbook case of mayhem, and there are numerous cases from New York.
Based on New York law and our law.
Yeah, New York law and our law. If you look at other statutes and from other states, also specifically put the ear within the context of the statute. You can look to California Penal Code 203, Massachusetts Chapter 265. I mean, there are multiple statutes and case law recognizing the ear specifically, the nose, the lips. And a lot of this comes from the history of the crime of mayhem. So originally, back in the day, at common law, it was about chopping off the limbs, right? And so it was an eye for an eye. If you chop off my limb, I chop off yours. And then when the Coventry Act came in 1670, where Sir John Coventry's nose was slit in Parliament, they then decided, well, this should be also a crime, this idea of disfiguring, cutting nose or lips or other parts. And there was an expansion from the common law of just looking at the members or like cutting off your body to looking at disfigurement. And so that expansion from the Coventry Act is seen in statutes all across the country in thinking about disfigurement. So you're absolutely right, Your Honor. This is textbook and classic type of mayhem.
But those cases deal with the ear lobe, right? And in this case, there was a lot of testimony that it was not the ear lobe, it was I forget the name, but it was basically on the outside of the tip of the ear.
It was the helix is actually what it's called. It's the pinna is the outer ear, and this part is the helix,
Right.
the medical term.
And I think, you know, but you still need to deal with section 1344.
Right.
And no matter how bloody and messy it looked in the photographs at the time of the injury, this law requires that if at the time of trial, the person in personal appearance, not in what someone say or how they feel or how they can't sleep on it, it's on their personal appearance. If it appears that he is recovered, that he is no longer disfigured by it in personal appearance, then you cannot be convicted of mayhem. So at trial, did the government allow the jury to get a close view of him in personal appearance so they can look at both ears to see if the way it healed, if it simply was not that disfiguring, rather than to rely on the fact that the doctor said it was a mild disfigurement? I think at trial, at personal appearance, a person can get a big slash in their face, but by the time it comes to trial, it have healed, you don't see any sutures, you don't see anything. And therefore, it would seem to me that this section would not allow a conviction for mayhem, but it says that you may still be convicted of assault in any degree. In this case, did the government have an obligation to have the jury look at this defendant to determine, based on his personal appearance, that he had recovered sufficiently that he would not be considered disfigured?
I think the government met its burden with respect to providing sufficient evidence on 1344. While a record doesn't show that.
Tell us what the evidence is that the jury was able to look at his physical appearance, his personal appearance, and make that determination. Was it him sitting at counsel table? Was it him when he testified? Which ear was to the jury? Were they able to actually make this determination?
Well, the record doesn't specifically tell us whether there was a moment. So for example, in McKinnon, there was a moment, and in a lot of the cases you'll see where you show your arm to show where the scar, where you were bitten. So we didn't have that moment in our record. But what we do have.
If you don't have it, then how do you demonstrate to the jury that, how can you show this court that he did not appear? It may be that, you know, the ear may have healed and there may be a little indentation, but you can't see it. It's not that visible. But on this record, how do we know and how can we determine that the jury was ever afforded that opportunity?
Well, what I would look at and what the court should look at would have to be the testimony and the photos. Because the testimony from—
I'm talking, but those testimony occurred in St. John. Those photographs were taken at the clinic in St. John way before a trial. And this section, you know, you can't read over it. It says, when upon a trial for mayhem, it appears that the person injured has, before the time of trial, so far recovered from the injury that he is no longer disfigured by it in personal appearance. Since we don't have to worry about whether or not the ear was working, there was no testimony that he couldn't hear from it anymore. Is there an obligation by the government to display the injured limb or organ to the jury so that they can determine whether or not in personal appearance it is considered disfigurement based on your objective standard in this case?
And my answer for that would be this. The statute says upon at the time of trial for mayhem. And at the time of trial, the victim was visible to the jury while he was giving his own testimony and while he was sitting at defense table. Based off of the record, there was enough evidence that the fact that his ear would not grow back. So there was
But
sufficient.
considering that this is an element, you know, I mean, that you
Well, the
usually
jury
take all
wasn't.
the elements, you would point to the defendant to identify them. You would think that here you would actually have the jury, have the defendant display his injury to the jury so that they can see it. If it was covered under hair or under a hat or something else, well, I don't think you would have a hat in trial testifying. But if it was covered and the jury never got a chance to see it, how do we know that the jury was able to satisfy the requirements of 1344?
Well, we know the jury received an instruction on 1344. So when they deliberated, they were well aware of this statute and this provision and the requirement of recovery at the time of trial. And they could have made that decision when they deliberated, but they did not. They looked at the record and looked at everything before them, the multiple pieces of evidence which came through, the fact that the ear piece of the pinna or the helix was in a cup and it could not be reattached. It was no longer viable. And the fact that the pictures or the photos were bloody, we all have ears. We all know exactly what it looked like.
Everybody have different shaped ears, and you don't know how this would look when you look at the person at the time of trial. But let me ask you, what was the basis of this charge? Was it, it says whoever willfully and with intent to commit a felony or injure, disfigure, or disable, inflicts. In this case, was it based on him with intent to commit a felony or with intent to injure? And there was no conviction on the assault charge if that was the felon, is the underlying felony, correct?
Right. The assault charge, well, count one was the assault charge, but the count two of the information says with intent to injure, he willfully beat it off.
All right, so it's as the alternative with intent to injure rather than to commit a felony.
Exactly.
With regard, Attorney Gregory, with regard to section 1344, do you think that section adds is an element of the offense of mayhem, or did your research disclose, if it did, whether or not it's more akin to an affirmative defense?
I would believe that 1344 specifically says on the face of the statute, recovery of injured person as a defense. So while, and this is just plain reading of the statute, this would be as a defense, which is why it was included as an instruction. But we look to 1341 for the elements of this crime. And there's sufficient evidence regarding the intent and regarding the serious disfigurement, which you can find any statute regarding serious disfigurement, different language regarding it, especially from New York.
But
So
here where it says no conviction can be had, no conviction for mayhem can be had, doesn't that mean that you cannot have a conviction where there has been a recovery? And this is why I asked counsel before whether or not it was a defense or an element.
I understand, yeah, sorry.
But here it says that no conviction can be had for mayhem if the person has recovered. So doesn't that kind of make it more of an element that the government has to prove that or disprove?
We look to the plain reading of the statute first, and it's styled as a defense. And I don't believe that the government, even if it was deemed an element, that the government failed to prove it, given the evidence presented by the victim himself in his testimony and Dr. Barreau recognizing the permanency of the injury. We cannot grow that ear back. It is no longer viable. Only stem cells could reattach this ear, and it's just not going to happen. And so we have to decide as a territory what we want to deem mayhem to be. And this is textbook and classic. The fact that an ear has been bitten off.
Attorney, before your time run out, I want to get
Already run out, I think.
Before we run out,
Okay.
I want to get this in. Mr. Williams testified, all right, and he said, he was asked the question, did you see the man that bit off a portion of your ear? The ear was severed. It came off. Yeah. There's no recovery from that. It's permanent. Even though the doctor who said it was a mild disfigurement, it's severe, it's gone. You can't reattach it. No amount of sutures could bring that ear back. It was bitten off entirely and it was dead. So that is, for all intents and purposes, that will give you a good impression, which is consistent with the photograph that the juror saw. So at the time of the jury, at the time of the trial, the fact is it was a permanent disfigurement. The hair is gone. It's dead. It couldn't be reattached. The doctor said that. So
Is that a question? Was that a question or?
No, well.
Oh, okay, no, I'm just waiting because the time has expired and.
Oh.
Yeah, all right, okay, well, I just want to make that clear because.
No, if you were asking a question, if it was a question, I would allow her to answer it.
Yeah. All right. Is there any way around this in terms of that injury not being a permanent injury?
There's no way around the permanency of the injury. It's simply a fact that the ear has been bitten off and cannot be reattached. And what government will say is that 1344 was clearly a defense and could have even been used during trial. The fact that it wasn't raised until the instruction shows that it wasn't being used properly by the defendant. And so in closing, our position is that there was more than sufficient evidence for mayhem.
Okay, thank you.
Sorry, thank you, Your Honor. I want to start with addressing the people's position that the caption or the title of Section 1344 is somehow part of the plain language of the statute or dispositive of whether that statute is an affirmative defense. And I would direct the court to 1 VIC Section 45A.
We're familiar with that. I don't think you need to waste your argument on that.
Okay, thank you, Your Honor. I just wanted to raise that the title of the statute is not part of is not part of the language. With respect to the people's invitation to this court to craft a definition of serious disfigurement, I would say that this court's obligated to defer to the legislature to the greatest extent possible in coming up with such a definition, and that Section 1344 is enacted by the legislature and intended by the legislature to be part of the mayhem statute. That language within the statute is clear. And so before this court looks to the law of New York or Massachusetts or the Coventry Act or any of these other things, it must give deference to all of the Virgin Islands Code. And what the Virgin Islands Code anticipates, regardless of the common law history of the charge of mayhem, is that in order for a serious disfigurement to constitute, for that element to be fulfilled under the meaning of Section 1341A1, that there would need to be something that the jury can see at trial, not at the time of injury, that indicates that the injury is a serious and permanent disfigurement. And I don't believe that there's anything in the statute which says that any permanent alteration to the body is a serious disfigurement. There are some which are obvious. If somebody loses an arm, loses a leg, that is obviously, and I believe in all cases.
Attorney, that statute just read from, remember, it doesn't talk about amputation. It says seriously, and I quoting from the statute, seriously disfigures his person by any mutilation, any mutilation. If that ear isn't mutilated, then nothing else is. That's what it seriously disfigured his person by any mutilation.
Well, Your Honor, if there was serious,
it has to be a mutilation.
But there was not the testimony at trial from the doctor. The testimony at trial from the doctor is that the ear is fully functional and therefore the disfigurement would be mild. And that was the facts in front of the jury.
Okay, very well, thank you. The matter will be submitted.
Thank you, Your Honor. Having no further business before the court, I'd ask to be excused.
You may.
Thank you.
Thank you, Your Honors.